What's up everyone, it's the Law School Lumberjack here again with another video. I hope you're having a great day. I've taken a little bit of a break in 2021, but I'm back, ready to do another video, and without further ado, here's a new entry in our Contract Law 101 series. Today, we'll be talking about the doctrine of fundamental breach and their applicability to exclusion clauses. Now, one of the doctrines I found the most difficult to understand in my first year law school contracts course was the doctrine of fundamental breach and its effect on what are called exclusion clauses. So I thought I would go through that today to give you a hand. This video hopefully will be relatively short. It's meant to just give you a brief primer on what fundamental breach and exclusion clauses are, give the lay of the land, so to speak, with respect to fundamental breach, as you'll learn in your Canadian law school courses, and hopefully provide some insight so that when you're learning about fundamental breach, it makes a bit more sense, because it can be a very difficult topic to wrap one's head around. Now, this doctrine is very jurisdiction dependent, so this video will largely focus on fundamental breach in Canada, as you will see in Canadian law schools, although the doctrine itself and the information surrounding it hopefully will be the same in all jurisdictions, although the treatment of this doctrine may be different from jurisdiction to jurisdiction. So a lot of you are probably wondering, what is a fundamental breach? Well, fundamental breach was a concept or doctrine first created, to my knowledge, by Lord Denning in a case called Karsales and Wallis. Essentially, what a fundamental breach is it's a breach that is so severe that it goes to the heart of the contract. And Lord Denning held that such a breach, being the fundamental breach, was so egregious that it disentitled the offending party, or the one who engaged in the fundamental breach or caused the fundamental breach, from relying on any exclusion clauses. Now, for those who are taking classes and may not know what an exclusion clause is, or may not have that explained to you, essentially what an exclusion clause does is it limits or absolves a contracting party from liability should a certain event occur or should the contract be breached. So basically, it's a term or a clause in a contract which basically carves out liability in the case of a breach of contract. What Karsales and Wallis does is it creates this doctrine of fundamental breach and essentially holds that if there is a fundamental breach in a contract, a party who's protected by an exclusion of liability clause then cannot claim that exclusion of liability clause to protect themselves. Now, you might be wondering, why is it such a big deal that fundamental breaches affect exclusion clauses? Well, what's helpful about that for a party who's trying to sue is that normally your remedies are either to sue for damages or to seek that the contract is essentially torn up or unenforceable. What a fundamental breach allows you to do is, while you can still kind of uphold the damage element of the contract, you can attack a specific provision, being the exclusion of liability clause, which then in essence lets you take away the shield of the offending party and seek damages against them. So in theory, it was a very powerful tool, and I think in Lord Denning's mind, what it was meant to do was to protect weaker parties. So by way of example, I'll explain what fundamental breach is and what fundamental breach is not. Now, I'm a big fan of The Office, so I'll kind of intersperse a bit of Office humor into this example. So let's say Mr. Shroot wants to buy a car from Mr. Scott. And he sees this Sebring that's quite beautiful, good condition, and Dwight really wants to purchase it. So they enter into a contract to purchase the vehicle. The next day, before the vehicle changes hands, Mr. Scott accidentally drives the vehicle into a lake and then proceeds to provide Mr. Shroot with the vehicle that's no longer in working order because it's essentially flooded. Now, I think that would very well be an example of a potential fundamental breach. The car was a working car, everything was good, and suddenly now Mr. Shroot has a vehicle that doesn't work being offered to him. So let's use a different example to show what may not be a fundamental breach, or what, for example, on a law school exam wouldn't go to the heart of the contract. So again, Mr. Shroot views Mr. Scott's car. While driving to drop the car off for Mr. Shroot, Mr. Scott accidentally scrapes the side of a pole, and so now this Sebring has a small dent in it or a small paint scuff on it. That I don't think would go to the heart of the contract. For example, it could be fixed very easily. In that circumstance, Mr. Shroot would likely have a claim against Mr. Scott for some damages potentially, but it wouldn't go to the heart of the contract such that it's a fundamental breach. So to recap, the doctrine of fundamental breach essentially says that if there is a breach that goes to the heart of the contract, any exclusion of liability clauses set out therein cannot be relied on by an offending party. So what essentially happens is this law initially gets ported over into Canada, but there's some public policy issues with this. For example, while Lord Denning intended this fundamental breach to protect weak parties or parties who have an inequality of bargaining power, instead it wasn't necessarily used as a consumer protection mechanism. It was being relied on even by parties with very strong bargaining power. The other criticism, among others, was that two parties on relatively equal playing field could still make an agreement that the exclusion clause should apply essentially even where there was a fundamental breach. So there could be consensus at Edom, using my past example, for example, with Mr. Schrute and Mr. Scott, that Mr. Schrute was going to buy the car regardless. Now, if Mr. Schrute gets cold feet and later argues, well, that's a fundamental breach, that doesn't really uphold the consensus at Edom or the real contract that was struck between the parties. So what happens in Canada is over time, this doctrine essentially erodes to the point where it's no longer applicable in Canada, and you'll see this in your law school courses. I'll briefly kind of name drop two cases here. I'm not going to provide a fact summary or a case brief on them. If you do want me to go through them in great detail or greater detail, please feel free to leave a comment down below. If I get enough comments, I probably will do a case brief video on them. But the first case that kind of starts this ball rolling towards the erosion of fundamental breach is a case called Hunter and Syncrude. So essentially what happens in Hunter and Syncrude is the court says that fundamental breach is not the proper doctrine to be using when you're determining whether or not exclusion of liability clause or limitation of liability clause should be upheld. It's better to use the doctrine of unconscionability than that of fundamental breach. Now, the final nail, so to speak, in the doctrine of fundamental breach's coffin is the case of Tercon Contractors and British Columbia. Essentially what happens in that case is the Supreme Court of Canada essentially does away with the doctrine of fundamental breach and instead creates a three-part test to determine if a exclusion of liability clause should be upheld, especially in the context of a breach of a contract. So the test is as follows. Part one is the exclusion of liability clause drafted in such a way that it catches the situation in question? So for example, using my previous example with Mr. Schrute and Mr. Scott, if Mr. Schrute and Mr. Scott agreed that if my vehicle somehow stops working, you still have to pay me for the vehicle and take title to the vehicle and you won't sue me for that, I think then it would be clear that the exclusion of liability clause would apply to the situation at hand. Now, if that's the case, and yes, this clause does apply, the question then becomes, should the clause be rendered unenforceable due to unconscionability? Now, if you don't know what unconscionability is, feel free to go through some of my old videos. I explained the doctrine of unconscionability. Essentially, the question becomes, did the party seeking to rely on the exclusion of liability clause have such great bargaining power and take advantage of the weaker party such that the exclusion of liability clause should not be upheld? So if you pass number one, in that the exclusion of liability clause applies to the fact scenario, you pass number two in the sense that there is no unconscionability, the third question becomes, is there a public policy reason why the exclusion of liability clause should not be upheld? One thing that might cause an exclusion clause to be rendered unenforceable for public policy reasons, for example, is if it contravened a statute or contravened common law in that it was illegal. Now, there's obviously more ways an exclusion clause could be found unenforceable for public policy reasons, but those are kind of two examples of how you may have a situation where an exclusion clause, which on its face may be seemingly applicable, could be rendered unenforceable. I hope this video was helpful. If it was, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. See you next time.